everybody for coming. We have a few more folks coming, so we're just going to wait a couple more minutes. We're not going to start too late. I apologize for the hike that it took to get back here. Earlier today, I set up some balloons to kind of get people's attention, and I made the mistake of doing it while school was still going on. And so I think some kids popped them as I walked away. So while I'm mad that they popped them, I am happy to report the kids are still the same. So we'll get started in just a few minutes. Good evening. We'd like to welcome everybody. Thank you for coming to tonight's estate conservation workshop. My name is Michael George. I'm with Safe1 Credit Union. A lot of times when people hear the term estate planning or estate conservation, they immediately think of some wealthy individual or family who live in a big house and have big cars and have inherited millions of dollars. But the fact of the matter is that you don't have to be a Rockefeller or a Kennedy or a Carnegie, or I guess a modern day one would be Kardashian, in order to take advantage of these financial vehicles. Tonight, Garo Ellis, a financial advisor with MoneyWise Wealth Management, he's going to help you navigate and simplify the estate conservation and estate process. Garo's going to cover estate planning fundamentals, challenges, distribution techniques, important documentation, and current tax laws. We're going to focus, going to give you information on your need for to take careful action when it comes to managing your estate as well as your conserving your assets. So I want to take the opportunity to introduce Garo. Garo is a fiduciary financial advisor and original co-founder of MoneyWise Wealth Management. In this role, he regularly couples, families, and businesses to better understand their financial goals and how to achieve them, especially when it comes to retirement and retirement planning. In addition to his duties as a financial advisor, Garo is also co-host of the Money Wise Guys radio show and podcast. He also moonlights as a country music singer who's written over 30 and I've heard some of them, and you can get them on Spotify. He might talk about that a little bit tonight. And during baseball season, he can always be found watching a Dodgers game with friends. So, yeah. Oh, he never calls me because I'm a Giants fan. So I can personally tell you, Garrow is a dynamic speaker, and he provides great insight on what he promotes. So you're in for a treat tonight. So with that, I'm going to introduce Garrow Ellis.
Thanks, Michael George. Thank you very much. Thanks for having me. And as far as being dynamic, it's hard to be dynamic when you're just talking about a trust, but I'll try to make it as entertaining for you as possible. But a few housekeeping items. There is evaluation sheets on your tables. If you want to give me a grade of F after this, feel free to do so. You can do it right on there, or schedule an appointment, or several different questions on there that if you'd like to fill them out, that speaker and our company out to help us improve, to deliver important information, we believe, to the public like yourself on how to become more money wise. Bathrooms are through that door right there, right? Yeah, right through the door. And snacks and water are back in the house. And Dodgers do start at 7:10, right, Charisse? Frank, 7:10, right? Okay, so we'll have you out by. Did you record it? Yeah, I recorded it. So I usually start mine a half an hour late so I can kind of skip through some of the commercials. So 7:40 is perfect for me, but we'll have you out probably prior to that. But this is important information. You know, when we welcome you to this estate conservation seminar, and as a company, you know, we started back in the year 2003 as MoneyWise. We were advisors even prior to that, but officially MoneyWise did start 20 years ago. March was our 20th birthday on the radio, and we're not skipping a beat. Typically, radio shows typically last. They go through peaks and valleys, and you know they typically only last 5 years. They peak out, and then in the 6th, 7th year they're done. And that's a good radio show. But pretty proud to say we've been on delivering important information for y'all, and how to become more money wise. And we committed back in the day. You know, we use to dedicate ourselves not to just becoming a financial services firm. We committed ourselves, and that was part of our business plan. Commit yourself to educate the public, and we continue to want to do that, to educate you on how to become more money wise, but as well as retire comfortably, set your goals, and again, just teach you everything about money wise. And that's not what this is about, because that's another whole nother seminar on what you need to know as far as goal setting and what we do as financial advisors, meeting with clients, setting their goals, understanding their goals. Do you have a trust? Do you have a will? You know, financial planning is just not about stocks and bonds and mutual funds. It's about planning and understanding and having a good trusted financial advisor that's a fiduciary that does right for you. You know, the Department of Labor wanted everyone to jump on our side of the fence, because there's your stockbrokers, and that takes a certain license. But with to become a financial advisor, you do need a certain we call it the law license. It's the securities law, and to jump actually called a financial advisor. The Department of Labor wants everyone on our side of the fence simply because we are held to a higher fiduciary responsibility to do what's right for you, understand you. You know, before we talk about investments, we need to understand where the roadmap's going, who you are, where you want to go, what's your goals. And so that's what a fiduciary is, if you didn't know that. So if you are looking for a financial advisor, whether it's with MoneyWise or whatnot, or your own guy, make sure he's a fiduciary, because the Department of Labor is going to have everyone eventually have to take that test. And right now it's only a 49% pass rate or something like that, Justin. Down, lower? Wow, that's too bad. They have to make the test easier. Yeah. All right. But again, our commitment extends beyond simply offering financial services, and that's why we're here today. And today we're here to talk about estate conservation, preserving your wealth. And so let's get going. There's our commitment, as usual. As I kind of just said, you know, we want to provide sound financial information. We want to help you identify your goals. We want to strategically prepare you for your retirement future, as well as other things that you're setting your goals on. Let's open this up, and we'll begin our discussion with some estate lessons from the rich and famous. Y'all have heard of one of my favorite, actually. She wrote a song called Respect, Aretha Franklin. Well, Aretha Franklin, you can check my phone out. Most of the songs on my phone is Aretha Franklin, but she passed away in 2018 at the age of 76. And she did have a lot of songs. She had a lot of so not only written songs, but as well as royalties coming from different songs, as well as an estate that was uh, very wealthy. And but she passed away with no formal will or estate plan, which is a financial advisor. It shocked a lot of us. And when that came out, we even talked about it on our radio show. Um, and it can still take years to settle her estate at a very high financial cost. You know, what happened was they said that, well, when they first got it together, the boys or four sons filed documents in Michigan probate court, and they wanted their niece to be the trustee of settling the estate. The four boys didn't want to do it. They said, "Well, let's get our niece to do it. She's kind of outsider looking in." Well, she eventually resigned because of disputes between the brothers. I mean, see, they came from the woodwork, so trying to figure out who gets what and what get. You know, and trying to settle this estate. So it is rather messy. It's still going on some of the royalty issues. And Aretha Franklin's one of them that didn't have a trust, didn't have a living trust or a will. Now, Michael Jackson, he did have a revocable living trust. He sat down with an attorney, got a nice document ready, and put it in a binder. Gave it to Michael Jackson's estate. Say, here's your living trust. Um, and the executor and litigation issues are still going on today. Why? Because a lot of it, and Frank probably understands what I'm saying, but I will explain this later. A lot of his estate was not funded under trust name. So you can have a nice little trust drawn up, and again, I'll talk about this later. I don't want to confuse you yet. Nice trust drawn up, say, hey, here's who I want to leave my assets to. But unless an asset is put under trust name, it still goes to probate. And so he had a nice trust drawn up, paid millions of dollars for knowing him, and didn't move some of his assets under trust name. And again, I'll explain that later. I'll come back to that. Okay, let's talk about some of the fundamentals here. What is it? What is estate conservation? Why is it important? No, there's two goals in mind. You know, when you're thinking about setting up your estate or talking about conservation, manage assets during your lifetime, okay, while you're living, and then distribute assets upon your death. So we're going to talk about there's two goals there, and I'll continue to talk further about them. But the principles of estate conservation, let's first of all talk about the fundamentals. Well, we'll go through fundamentals, talk about the challenges, talk about basic distribution techniques, and then trust strategies. My whole goal for you guys today is to walk out of here with more information. And if you do have questions, it's not rocket science. That's what we're here to tell you. I'm trying to dumb it down a little bit because, again, like Michael said, a lot of people hear living trust and irrevocable trust and charitable living trust. Don't let that confuse you. As far as I'm concerned, every client that comes sit in front of me, I ask them one question after we're all done. Do you have a trust? Do you have a living trust? After I gather the information and understand that they have more assets outside their retirement accounts, a lot of people do. What about your children? And again, who's going to watch your children? Do you have a will? So there's more involved. Healthcare directives. So again, that's everything we're going to talk about. Not only the fundamentals, but the basic distribution techniques as well as trust strategies. How am I doing? Am I talking too fast? I tend to talk fast once in a while. How am I doing, Sharice? Okay. All right. So the benefits of estate planning. One of the main benefits is you can select who will receive your assets. And the reason I say that is because, well, Aretha Franklin, she didn't have the benefit of letting her estate know who she wants to receive all her assets in different categories, like her house, right? She didn't have a will. She didn't have a trust. Nothing was written down. She didn't have the benefit of that. Instead, it had to go to probate court, and her niece even resigned, caused resentment in the family. And then the court decided who gets her assets, right? She didn't have the benefit of that. But by setting up, the benefits of estate planning, if something should ever happen to you, whether you pass away or you can't think on your own, that who's going to have your assets, who's get your assets. So you get to select who receives your assets. The next one, determine distribution of estate. So when you do estate planning, you might have, like myself, when I set up my first trust, that I had young children. And if something should ever happen to me over the next 10 years until they became 26, 28 years old, I I didn't want them to get the money when they're 13, 14, right? They need guidance with that. You can you imagine or even a 20-year-old. Do I want my 20-year-old to inherit certain assets, and what are they going to do? Their frontal lobe's not developed yet. I told my kids that all the time. I said when they try to make decisions on their own, your frontal lobe's not developed yet. Get it developed and then come back to me. I'll make the decisions. So you determine the distribution of your estate. You can choose individuals to manage your estate. Again, go back to Aretha Franklin. Who did she have manage her estate? Her niece to start out, right? And then it was then the courts appointed somebody to manage her estate after she passed away. But when you do estate planning, you know right away when you're done, you can choose individuals to manage your estate if something should ever happen to you. Okay? It's called a trustee or an executor trustee, and if they're heading into it. Help reduce settlement costs. Probate costs money. So when it says help reduce settlement costs, um, how much did Aretha Franklin's estate cost to go back to court to get an attorney involved? Quite a bit of money, and including Michael Jackson was 4 times more than Aretha Franklin's, believe it or not, because they're just things were listed under trust name. So again, it can get quite costly if you don't do it. It goes to probate. Probate costs money, and courts decide who gets your money if it's not done correctly. Um, Choose guardians of minor children. This is very important to me. Early in my career, I always thought the same thing. So, well, why do I need a trust? I don't have a lot of non-qualified assets. I mean, qualified is my retirement account, and you can list your beneficiaries in there all the time. So it's taken care of. But what about my house? What about my prized cow? There, who gets these assets? So when we talk about minor children, that's what was important to me. An attorney told me at the time when I first got in this career. So, well, you need to do estate planning because you have children. I go, what do you mean? I said, he goes, well, if something happens to you, who's going to watch your children? I said, oh, well, my sister. So how do you know? Well, because I'll tell her. So, well, no, it goes to court, and the courts decide who watch your children. And I thought, well, wait a second. My father-in-law would want to watch my children. He would want to come to court and take the children and watch them in California. My sister's in Wyoming. And I talked to my wife, and she goes, oh, heck no. And so I said, I agree. I don't want my father-in-law watching my children, nor my mother-in-law, nor my mom, nor my dad. I didn't want any of that. I wanted my sister. That's who we sat down and talked about. So I wanted my sister to watch my children. So again, who's going to be the guardian for your minor children? Something to think about. And if you have grandchildren, you might want to pass that on to your children to talk about, ask them that same question. Who's going to watch your children? Is there a estate plan in order? Because that's all part of estate planning. All right, and then provide liquid capital for burial, settlement, and income tax costs. When you do estate planning, you can you talk about that. Say, well, how are you? Where are you? Where are you going to be buried? Where how are you going to save for that? Does it come out of the trust? Who is life insurance going to pay for that? So it's something that should be written down somewhere in order. Otherwise, it gets lost, and then your beneficiaries more likely than not. In my case, that's what happened to me. I did end up paying for an in-law to not only through her dementia and Alzheimer's. I'll bring her up as well. It's not the in-law that I was talking about before. It's I have 2 mother-in-laws, by the way. One stepmother-in-law and one real mother-in-law. And mother-in-law came out down with dementia, Alzheimer's, eventually passed away from it. But I'll bring her up gradually in this conversation because it's important to use her as an example on why estate planning is very important. All right. Let's talk about the town. Those are the fundamentals, the benefits of setting up an estate plan. Let's talk about some challenges. You need a qualified estate attorney, familiar with all aspects of estate administration, willing to work with other professionals. You can ask for referrals, friends, financial professionals, contact your local bar association. So finding a qualified attorney, Debbie does a good job with talking to local firms around here, getting to know them, having lunch. Debbie's right here, by the way. Wave, Debbie. And that's Sally, by the way. Justin's in the back, and Chris Pelster's here as well as a money-wise guy. Where's Chris? Is he still here? He's out directing traffic. And Frank Woldridge in the back. He's with a law firm as well. And is there any other attorneys in the house? I hope there is. Is there any other attorneys? No? Okay. Well, there's a good firm right there then that you can go to. But yeah, that is a challenge. Need a qualified attorney. You need a qualified attorney to set up an estate plan and meet with your professionals. We call it the team. Okay, when we meet with these individuals, attorneys, as well as you know CPAs, real estate lenders, we call a team. And when you meet with the MoneyWise guys, let's get a team together. Let's get your attorney. Let's get your CPA. Let's all meet together and figure out how we can create a estate plan for you. And a good attorney is hard to find, but they do need to be qualified and good at what they do. I believe, right, Debbie? We have a few in our books. We have a lot, actually. If you need one, reach out. You can ask a referral from a friend or financial professionals like us. I know a lot of good estate attorneys here in town. Okay, but it is a challenge. Probate, the court proceedings that conclude all the legal and financial matters of the deceased. So again, if you pass away, you don't have any direction on your estate plan. um, your uh, your house, for instance, if your house isn't under trust name, if it's just under your name or joint name, you could be community property with your child. That's fine, or joint ownership. But if you don't have anything under trust name, it goes to probate. Okay, just think about that. So if you have a brokerage account at let's say, Ameritrade or Schwab, and it's not an IRA, meaning you're just saving money, you're tucking it away, and a savings account at the bank. Let's say you have $30,000 at savings account at the bank, and you have your house. It's got $500 or $200,000 worth of equity. Something happens to you, that money, that house, that savings account, that brokerage account, all goes to probate, and the court decides who gets your money. Okay, you can take your will to the court, and it'll help settle that. But all that goes to probate, and they're going to decide who gets your house, who gets your savings account, who gets your brokerage account. Again, this is why, again, we're getting to what we can do to alleviate that, to solve that. I'm a solutions guy. So probate, we want to try to avoid. Because here's the facts about probate. It can be expensive. Costs vary, obviously, depending on the state. Attorney fees add to the cost. Probate can take a long time, often takes a year or more. I've seen much longer. Michael Jackson's is still going on. Aretha Franklin's is still going on. They were bigger estates. But again, it depends on who comes from the woodworks when in probate court to figure out, hey, my name's Uncle Charlie, and I lent money to Lenny 80 years ago or 20 years ago, and he hasn't paid me back. I'm here to make sure I get paid through probate court. You know what I'm saying? People can do anything. Even though you know what your directions are, it's not written down. It goes to probate, costs money, and it can take a while. And by the way, probate offers no privacy. In most states, the proceedings of the probate court are a matter of public record. Okay, that's why we know about Michael Jackson and why we know about Aretha Franklin, why we know about all these other people, because it is a matter of public. By the way, a trust is not. If you set up a living trust, it is not part of public record. Estate taxes are obviously levied by the federal government and some states on any property that passes from the dead to the living. The step up in basis on inherited assets is an important consideration that might affect your gifting strategy. So when we talk about preservation of estate and we talk about step up in basis and taxes, it's very important. So when you sit down with me and I'm doing what we call a discovery process to get to know you on why I'm investing your money or anything else, I do ask. I said, okay, what's the square footage of your house? The reason I ask that is because I know what prices per square foot are per area. Remember back in the day when you had 1,000 square foot house and people asked you what the price of your house, what's the value of your house? And you said $800,000 during the housing boom. Well, we started asking square foot now for us to come up with a value, and as well as you. So you have equity in your house, and the step up in basis is very important, because if something happens to you, the value of if you buy a house at $100,000 and it's worth $500,000 today, and you add a beneficiary to that, first of all, you're gifting money to that beneficiary. It needs to be reported as a gift, and he inherits that person that you just put on your joint ownership of that property. They now inherit your cost basis, meaning $100,000 you bought it for, it's worth $500 a day. Had you not done that and you passed away at $500,000 with a nice living trust, the beneficiaries inherit your house with a cost of $500,000. So they can turn around and sell it for $500,000 and not pay taxes. Does that make sense? The originally cost was $100,000, worth $500 a day. Something happens to them, they leave it to their beneficiaries. The new owner, the new beneficiaries, receive that house at a stepped up basis at $500,000. They can turn it around and sell it for $500,000, pay no tax, or keep it. Okay, step up in basis. It's an important note that you should have on. If you're taking notes, put step up in basis. It's very important for not only houses, for stocks, for bonds. Yes, yes, they are. And we're fighting against it tooth and nails, and they're probably not going to do it. So hopefully they don't do it. But they did try to get rid of the step up in basis. As far as not doing it, yeah, the financial industry can be very powerful. So, when there's advocates for us, depends on what side of the aisle they're on, I guess you could say. And so they're always fighting for us. But right now they didn't pass it to go away. It's still going to exist. It's not a permanent legislation, like you're saying. You know, the Tax Reconciliation Act of 2012 and all that made a lot of things permanent in estate planning. That's not one of them. So yeah, can they get rid of it? They can. But state step up in basis for a financial advisor is very important, and especially for our clients that have had property for a while. Farmlands. Can you imagine farmlands that were bought for, years ago? Let's say you had a family that lives on a farm. They bought it in Kern County for $10,000, which is a lot of money back in let's say 40. Well, that farmland today is, let's say, worth $10 million. Can you imagine the capital gain on that if they tried to sell it? But if they got rid of the step up in basis, they inherit the original cost. They don't get that step up in basis. So, yep. Any other questions on step up in basis? We're going to continue to talk about it. Okay. Did that help? You understand it? Step up in base, step up in cost. Okay. Recent changes. Remember I just talked about the American Taxpayer Relief Act of 2012. It did make permanent a lot of the changes that they started in 2010. So a lot of the 2010 changes headed into 2012. They made provisions from the 2010, but portability of exclusion between taxes, reunification of estate, and gift tax exclusion. And I'm going to talk about that. Raise federal taxes from 35% to 40%. So estate taxes were raised to 40%. But a lot of things they did in 2010 made them all permanent, which is actually good. There's one time, remember when, Justin, I don't know if you remember this, remember when estate tax exclusions were only $1 million? You had to stay below your estate, it had to be under $1 million. Well, now it's above $5 million. So and I'm going to talk about that, but the portability of exclusion between spouses, it's each. So when I talk about the gift exclusion, it's for each person, so your spouse as well as you. Meaning, if if your estate's worth $7 million, $5 million, and you can gift away $5 million, then your spouse can too. Okay, so it's including your spouse. So, did I have it up there? Where is it? I thought it showed it. Nope. So how do federal estate taxes work? You have the net value of estate, meaning if your estate's worth $10 million and you get an estate tax exclusion of $5 million, now your taxable estate's only $5 million. $10 million estate, reduce it by $5 million excluded, and your estate tax rate is your taxable value of estate is only $5 million. So your tax exclusion, your gift exclusion reduces your estate. I think it's on the next slide. That might help. Yeah. So you can gift money. Again, let's say you have $1 million. You're well under the estate tax exclusion because lifetime exclusion is $12.9 million. So you have to, if your estate's under that, you're fine. But a lot of people want to get it out of their estate anyway and start gifting. So you can gift $17,000 per person per spouse. Okay, so if you're a couple and you want to gift to your child, you each spouse can gift $17,000 to a child, or anybody can gift it to me, $17,000 each. So you can gift me $34,000, and you stay away from the gift tax reporting. Okay, Anything above and beyond that, you have to report it, and it goes against your lifetime exclusion. Make sense? So if it's $12.9 million and you gift me $100,000, you're above that $17,000. So the rest of it has to be included in a gift tax report, and it just goes against my exclusion. That's all. But good luck trying to gift away $12 million. If you can do it, great. Come see me. Um, but it's all part of estate planning, is it not? It's all part of that, and there are individuals that have that, and it's important for them to understand what the exclusions are, how much to gift, where we should start. It's all part of the family estate tax or estate planning. Unlimited marital deduction. So again, transfers of wealth between spouses are exempt from federal estate taxes. No, so here's what that means. So if you inherit money as a spouse, you gain their exclusion, meaning you don't have to. If you give it to a child, right, the child gets the assets, but the exclusion amount is for the individual, the spouse. But as a married couple, you gain that too. So again, if your spouse has 12 million and you have 12 million, they can gift it. They can give it. It goes to the spouse. They don't have to pay tax on it. But now the spouse has how much money? $24 million. If something happens to her, then she has $24 million, well over the gift tax or the estate tax of 12 million, and now she's got to pay tax above and beyond that. Now there is portability returns, so you can have a portability clause, and your accountant can fill that out and remove that once that happens. But again, just understand that the max of is $12.9 million. All right, here's what we talked about before: step up in basis versus carryover basis. Okay. Um, like I said, what is step up in basis? We all have a good understanding of that, right? What is carryover basis? So, a lot of people we found, and I'm sure other business people in the industry out here understand it as well. I meet with people all the time, and I say, "Well, who gets your house?" Well, my son does. Okay, how do you know? Because I put him on my deed. I put him on the house. Okay, so let's say they bought the house for $100,000, or she did, the gal, let's say, and it's worth now 500,000, and she wants to protect her estate, so she puts her son on the deed, which means he inherits half the house, right? It's rights of survivorship, right? That's the way we own most of our stuff. Married couples, you have a joint account, right, at the bank. If something happens to one, something goes to the other. He says, "No, I'm not giving." So if you have a joint account, if something happens to you, your spouse gets that account, right? That's joint tenants with rights of survivorship. Most houses are owned that way too, with your spouse. But you can also put a child on there. And if something happens to you, that house, joint tenant with rights of survivorship, the survivor gets the house. Problem with that is they inherit what? The tax, the cost basis, right? So they inherit half the cost basis, and that's what carryover basis is. Okay, that's understanding that. We always want to shoot for that step up in basis versus a carryover basis. And even if you put your child on it, you can remove them once you get your trust done and put your house under trust. Okay, questions on that? Yes. So what he said, he owns a house and he has a transfer on death on that house. Is that correct? No, you can do that. If that's the only asset you have and you can put a transfer on death through the mortgage company, and make sure your mortgage company knows as well as through the deed, yeah, you can do a transfer on death as well. That's all part of estate planning, sir. That's good.
Sorry. Is that inherited property that does not do step up in basis?
Yeah, good question. So he's saying if I put a transfer on death on my house, you're still the owner. So you didn't put a child on the ownership yet. The only thing, so they will get a step up in basis once they receive that house, whoever the beneficiary is.
I'll be clear. I'll be clear. I joint purchased a house with another person,
Okay.
and we have it as joint tenant transfer upon death. So whichever one dies,
Yeah.
it's not a spouse.
Oh, okay. So you did it. You have a house, joint tenants with rights of survivorship ownership, correct?
Correct. And I'm on the deed as a joint owner.
Okay, so if something happens to you, that house goes to the other owner.
Right. I'm more concerned about something happens to that person. What are my taxes?
Oh, but there's you can actually put transfers on death on bank accounts at Safe1 Credit Union. You know you do that all the time, right? Like
Yeah.
if you have a savings account, you can put a TOD on that account
Right.
where it transfers to the other, and you can actually do it for homes too. But that sounds like not what you did. You don't have a transfer on death on that house. It's just joint tenant.
No, it says TOD.
Okay, there's a TOD now. Okay, so you have a joint ownership. Who's the beneficiary then?
I don't have a beneficiary.
Huh?
I don't have a beneficiary.
You don't have a
We
beneficiary?
have two joint owners. So the question is,
Yeah,
if one of
that
the
makes
owners
sense.
die, then the other owner becomes the other person on the house becomes the owner.
Correct.
My question is specifically, what is the tax implication of the person who becomes the sole owner?
You still have your own cost basis. You still have the same cost basis as if no one
There's
was.
no impact.
No. Yeah.
Thank you.
But you should put a TOD on it. Just joint tenants right now. There's probably no TOD. Okay, good, good. Estate planning. See, he's on it. All right, good for you. Uh, appreciated assets could be subject to capital gain taxes, which could be as high as 24% for higher income tax brackets. And again, I think we understand carryover basis from step up basis. Yeah, test later. Good. Potential need for long-term care. I've seen this time and time and time again. You know, what would happen to your estate if you need long-term care for an extended period of time? I think have we had any loved ones in a long-term care facility or in a facility that costs a lot of money? Um, it's very high right now. You know, I've seen it as high as $15,000 a month. A good facility even is the cheapest maybe is what 6,000, 8. Yeah, so it can eat into an estate quite dramatically. So part of estate planning is we always, as a financial advisor, I always ask people if they have long-term care insurance. It's something you should look into. Because I can tell you this, there's, we insure our cars, we insure our houses, we insure, a lot of things. And we don't insure our long-term care. We don't insure ourselves. And the cost of that, and it depends on what it's going to eat into your estate. And it really depends. Say, do you want to leave money to your family? It's up to you. There's no cookie cutter answer to that. But long-term care insurance, I believe, if unless you're self-insured, that you can take care of it on your own and spend down an estate, is very important to look into long-term care insurance. Can be costly on the surface, but is it? Let's say it costs you $3,000 a month, or $3,000 a month, $3,000 a year, $4,000 a year, and you do that for let's say 20 years. That's $80,000. Okay, if your estate's at 800,000, it might be worth it, right? Just pay the $80,000 to preserve a lot of the assets. Because if it comes down to it, $8,000 a month is what $96,000 a year, right? Long-term care facilities that cost you $8,000 a month. You spend $80,000 for long-term care insurance, hypothetically. You do the math behind it. So go see somebody. $80,000 to have long-term care insurance for 20 years. And you just beat the odds when you get your loved one got placed into a facility that cost $96,000 per year. You see where you just saved an estate. It's part of it. Just I put it up there because it's part of estate planning that everyone should consider. Okay. Basic distribution techniques. Here's where a lot of people can get confused, but intestacy is through probate. Your last will and testament is the courts decide who gets your money. Intestacy. Will, you can drop a will. You can draw it on a napkin. Have someone witness, sign it, draw on a piece of paper. Will can be anything. I'd rather see a formal will through an attorney, but a will can be taken to court, whether it's legit or not. If it's signed or witnessed or whatever. But that goes to probate court, and then at least it helps the judge decide who would get who gets the distribution of your estate. So a will is very important. Jointly held property is another thing. Like I said, if you own a house or if you own a brokerage account with your spouse, if something happens to you and it's joint tenants, that house and that brokerage account goes right to you, right? owning a house in joint ownership, which most of married couples have. They have joint accounts. So that's what that is. If you don't, if it's under your individual name, I've seen this where they have a couple owns a rental property. And that rental property was put on only under the husband's name. He passes away. That had to go to probate, even though she's the spouse, right? So property, it wasn't held under joint ownership, nor was it under trust or anything else like that. And then beneficiary designation is another distribution technique. Now, how many people have a retirement account at work? IRA, 401k, 403b, 457. In those accounts, you have beneficiaries attached, right? When you open up those accounts, whether it's an IRA, a 401k, a 403b, or anything else like that, at work, you opened up the account. You're putting money goes in out of your paycheck, but that account should have a beneficiary attached. Now, state of California says your spouse should be 100% primary beneficiary because we're a community property state. So, but who's after that? What happens to you and your spouse? Is there contingent beneficiaries attached? So you don't need a trust. You don't need a whole lot of estate planning done, even when that is estate planning, by me asking you, have you checked your beneficiaries lately? Have you checked the beneficiaries of your 401k, your 403b, your IRA, your Roth, if you have one? Have you checked that? Your spouse is probably the 100% beneficiary, but what about after that? Or maybe there's nothing. A lot of times you set up these accounts online, or you maybe an advisor speeds through the paperwork and say, hey, we need to get this account open, get this transferred, and they fail to put in a beneficiary. We've seen it. So something happens to you and a beneficiary isn't listed on an IRA or a 401k, guess what? Goes to probate. Courts decide who gets that retirement account, which is probably should be one of your biggest assets. We find 401ks, IRAs, they are typically the biggest asset you have. Yeah.
How often should somebody update their beneficiary information?
I think right now, the next time you sit down with your financial advisor, you should go through all the beneficiary information and make sure it's updated now. And then once you have done that, you don't really have to revisit it. Matter of fact, make sure your advisor tags it in your account. Said beneficiary information updated. Next time they're in your office a year later, has your beneficiaries changed? Is your spouse still alive? Are your children all doing okay? If they're as beneficiaries. So it's a good question. But I would do it now. So the problems with probate court intestacy. Distribution determined by state law, right? The state of California has their probate distribution laws, and typically it's within family. So if you're married and you're that rental property I talked about goes to probate, well, the courts of California say, well, your spouse is first in line to get that. If she's not around, it goes to your kids. So there's a whole line of beneficiaries to the state of California. Fees and taxes. As I said, probate's not cheap. And when you go to probate court, there's attorneys that get paid. There's trustees or administrators that the court decides who's administrating that state. They get paid. Again, attorneys, administrators, if you don't have one. Again, designated trustees. So, and again, probate courts right there. Guardianship of minor children determined by the court. I wouldn't want that. That was the biggest thing for me. It was my kids. When I set up that's the first thing that hooked me into getting a trust done. I said, okay, I'll get a trust done. I don't have a whole lot of assets, but let me start it. So I did start it, and I had a little equity in my house, and that was it. That's the only thing out of my retirement accounts that I needed to put under trust, but it was for my kids. And I said, man, they kind of put again, it's all part of estate planning, right? Who's going to watch your kids? So a will enables you to control distribution of your estate. Like I said, a will you can document. It's not a legal document, really. It's a will. It's our last will and testament. That will, once you draw it on a piece of paper or type it up or whatever and sign it, and someone witnesses it, you now have a will that goes to court, which helps. So here's the will, judge. You decide who gets the money. And if you have a will, the judge looks at that and says, okay, at least that's something that helps me with my decision on how to distribute your assets. So you can control distribution of your estate through a will. Still goes to probate. Name guardian for minor children. You can do that on a will too. Judge still has to prove it. And elect someone to manage your estate. That's called your trustee, your executive trustee, your administrator. Who do you want to administrate your estate if something happened to you? You can all put that on a piece of paper. That's a will. Okay. So here's your estate documents. Your power of attorney, your durable power of attorney, your medical durable power of attorney, and a living will. So very important. The other thing that was very important to me after all the cases we've seen on TV or listened to things, messes in the estate world, power of attorney, it helps somebody. I can hire you as my power of attorney. And let's say I'm going to be out of the country and I want to hire you as my power of attorney that expires on September 30th, okay, to run all my affairs, pay my bills, everything else like that. Limited, but pay my bills, go to the bank, make checks, whatever. That's power of attorney. A durable power of attorney is good after you die too. So, or in case something happens to you, I'm sorry, if you become incapacitated. So if you could become incapacitated, I'm going to break it back down to my mother-in-law. So when my mother-in-law had early signs of dementia and and it seemed like it was getting fairly aggressive. She was all there. She was fantastic, laughing, going to the bank with me. And so I sat her down and said, hey, we need to start estate planning. And we need, if something should ever happen to you, we need to pay these bills, your home, your mortgage, your life insurance, your utilities, your car payment. And she understood it. And she made me her power of attorney while she was living. And she did become incapacitated. And good thing we had that power of attorney because, man, what a mess. I mean, we got letter after letter after letter and of she owes this on cable and this. And so we kept up with everything. Had I not done that, a lot of things would have went through credit. And the creditors would have came knocking at the door later on because it took a little time. And I was able also to place her in a home. Eventually, she stayed with us for as long as we could, and we found her a fantastic place. And that's where she passed away. But it didn't take. It was aggressive, but it was a good thing I had it, and it was a good thing she decided on. And I'm glad she made me. I didn't want to be. She didn't want her daughters, my wife, and her sisters, to be. Plus, it's hard on a family. It really is. It's hard to become as a son or a daughter or even a nephew or a niece or even a wife, whatever, have that durable power of attorney. But it's something that we do, for family. So it's very important to have that in place. It's part of the estate planning process. Durable power of attorney. Okay. How about medical durable power of attorney? Same thing. I had that. So when we went to the doctor, that I could sign off, I could do, I could bring her to the appointment. I could answer all the questions the doctor had, and get her get her medicine. So it was very important for us to have that medical while she was living, that medical durable power of attorney. A living will. I mentioned will about estate and financial issues, but a living will also, it can dictate, and I call it a healthcare directive, which most people do now. Part of a healthcare directive dictates, like my healthcare directives say, pull the plug. Don't, if it's not here, pull the plug, and it also dictates who's going to do it. So like the on here, it says living will. To me, it's a healthcare directive. And I had my sister, my older sister, as part of my healthcare directive to pull the plug. Didn't want my wife. Didn't think she could do it. She probably would. Didn't want my little sister to do it. My older sister my little sister gets my kids. My older sister pulls the plug. But it took a lot of thought, so and I've changed it recently. Because after my older sister, who was going to pull my plug, lost her husband, I realized that would be devastating. She still tore up over it. So I changed it to somebody else, Chris Pelster. Where is he? Yeah, Justin will do it. Yeah. But that's what it is. It's a lot of thinking, right? So who's going to pull my plug? Who's going to watch my kids? Have I mentioned stocks or bonds or mutual funds yet? I have not. This is part of estate planning, right? This is things you need to think about that we help guide you to, and your financial advisor probably is too as well, hopefully. All right. So jointly held property, joint tenancy, tenancy by the entirety, tenants in common. By the way, tenancy by the entirety, I don't think is available in California anymore. It's tenants in common, and I'll explain these. Joint tenants is what we know. Like I said, you're married, you get a bank account, you have joint ownership of that bank account, savings account, house. That's easy to understand. Something happens to you, joint tenancy with rights to survivorship. Something happens to you, the money goes to the other joint owner, right? Tenants in common is different. Tenancy in common is if you own a house and you sign up for tenancy in common, that means if something happens to one of the people, the ownership goes down line. Okay, so for instance, let's say you and I own a house together. You have children, I have children. So let's say we don't have spouses, but we owned a house or rental property together, tenants in common, not joint. Because if something happened to me, I didn't want you to get all of it, joint tenancy. She goes, well, joint tenancy with rights to survivorship, right? I wanted, if something happens to me, I want it to go down line. So I have my beneficiaries on the common side of it to be able to get that. So there's a couple ways you can own it. Okay, joint tenancy or tenancy in common, otherwise known as TICs. Huh? But most people do joint tenancy. But the good thing about that is it is a way to distribute money, right? If you have joint tenancy, you can distribute the asset. If you have tenants in common, you can distribute the asset. Don't need a trust yet. Here's the dangers of joint tenancy. Like we talked about, a change in property title could trigger gift tax consequences. Change in property title. Okay, so I own a house. Let's say my wife has passed away. I want to leave my house to my child, and I don't know anything about a trust. So I bring my child and I said, okay, you're 22 years old. I'm going to make you an owner of my house. It's worth $500,000. You are now half owner of my house because I just put him on as joint tenancy. So if it's $500,000 value and he's half owner, what is his share ownership? 250,000, right? How much did I just gift him? I gifted him 250,000, which should be reportable, right? As a gift. Because remember, you can only gift $17,000 a year. So if I make him part ownership, now I need to add, and he needs to put that on the gift tax exclusion report, which is fine. But that's what it means, trigger gift tax consequences. They're really talking about if the property's in Malibu and it's worth $20 million, right? Assets may be lost if joint tenants run into financial difficulty. Okay, my child that I just made ownership of my house, he now owns half my house. He becomes a hooligan and he's out drinking one night and he crashes into somebody else and kills the other person in a crash. He owns part of my house. Guess what? I could very well lose my house now. By adding him onto my house as a joint tenant, and he becomes a hooligan, whether it's any whatever, or it could just be an accident. Now the law can come after my house. Okay, so that's what that means. So be careful adding children. I'm not to say they're hooligans, but accidents happen, right? Potential tax benefits must be shared with other joint tenants. The benefits of this is the step up in basis, that we talked about earlier. Now you're just sharing it with whoever you added to your title. That's what that means. You're sharing your benefits that could only be yours and to your family. You're sharing it with any other buddy that you add onto your ownership of anything, whether it's a brokerage account or a house. Okay. Don't want to spend much time on that, but it's up there. Questions? Yes. Yeah. The homestead. It could. Yeah, on the when someone comes after your home, but when you're talking about estate planning, it has nothing to do with it. Yeah. can't get your share, but they can get his share. So you follow me? He's ownership of that home. He's no, no. Yeah, so it all comes down to creditors then. They don't care anything about homesteading. They're gonna come right after your house. Or they could. I'm not saying they will, at least his share. He you bought it for 100, worth 500,000. There's a lot of equity. There's 200,000 of equity in there. But if he's part owner in that, yeah, they can come after it. So, all right,
Carol, we
community
have a question.
property. Yes. Sorry.
Okay, so
That
what
was
if
loud.
the situation is you have a married couple, one, like my spouse, he had a former wife, she passed away, and he bought a house with her. She's on title and loan. What is the best way to handle that? Like, is that going to trigger a gift? Like, if I get put on title, or, you know what I'm saying? Like, the former wife was on the title that who passed away.
Yeah. So they would just need to go get her off the title. And take a death certificate. They need a
Okay.
death certificate. They need to understand why she's not going to be on title anymore.
But I'm saying putting me on there, would that trigger something?
No, you could be on it, and plus you'd own that house with him. So if that's what you guys decide,
Right.
and I tell people, no offense to you, but I tell a lot of people is that if you have separate property coming into it, are you married? You said,
So
Are-
is it-
are you married?
yes.
Oh, you're married now.
And I
s-
have my own property that I had before.
Yes.
us getting together.
So this is important because let's say now you have two different families, two different marriages. He was married, has a house with her on it. He can add you to that house and that becomes your house. And then now if you guys separate or get divorced, I'm just saying, I see this all the time, then you now have his house. You now have access to the ownership of that house. If he keeps it separate property going into that marriage, if he keeps it separate just under his name, then and if something ever happened to your marriage, it's his property still because he came into the marriage with that property. But once he adds you to the title, it's now yours. Same with your property. Yes.
Under that scenario, if you still have mortgage payments, and
What?
they-
I'm sorry.
I say if you under this scenario you just described,
Yeah.
where he adds her to the house, and let's assume that the house isn't paid for. Okay, now you have married couple with paying for a house note. So doesn't she then become part of that ownership because joint property paid
Yeah.
for the mortgage?
Yeah, what he's asking is she responsible for that lending? Meaning he went out and got a loan. He owes $200,000. His name's on the lender. Your name's on the title. He's still responsible for that loan. Because it's going to be hard maybe to get you on that loan. He's got to talk to the mortgage company or the lender and say, hey, she's now owner. Now I want her part of my lending. I want her part of the mortgage, right? And that's up to the mortgage company. So if that happens, then yeah, she's responsible for the lender. But if something ultimately happens, they can come after her.
And in the worst case scenario, if for some reason they decide to divorce later on, would she still be able to claim part of that home because marital funds paid for the mortgage during the marriage?
Yeah, she's on it. Because once she got that house and then she went out and bought a microwave and put it in that house. No, she bought a flower. She bought a flower vase and put it in that house and she contributed to that house. Yeah, yes.
What if you're married to somebody and they don't put you on the house, but you're married and you're both living in that house? If he dies, don't you automatically get the house?
Yes.
Or can he put his children on that house?
No, if
and
you're
they-
married and you're on
Uh-huh.
the house now.
But you're not, but he never put you on the house.
Oh, okay. Yeah.
But you are married.
And is it separate marriages like you're coming together after being married before?
No, they got married, they bought the house, but he never put her on the deed
Okay.
or the trust.
Well,
or the,
community property laws would step in and say,
Okay.
hey, but it would still have to go to probate. You have to
still
go to
have to go to probate.
Yeah. I mean, they,
But if he
course
put
decide.
it, okay,
right, Frank? Yeah.
it's a mess. Yeah, yeah.
Yeah. You guys have,
But I mean, but she would get it before his kids would get it.
Yes, yes, because it's as long as they were married a certain amount of time. But if it was only on now, if he came into the marriage owning that house, it is still separate property. But if they got it together, then it's community property laws. We're a community property state. Yes, Frank.
And I just need to make a disclaimer. I just
Ladies and gentlemen, Frank Woolridge from Young Woolridge.
Yeah, oh no, please. I just represent. I do our business development. But I've been around this for so many years, and that's exact scenario is what we see because what happens, and what Gary just said is, well, it belongs to the wife. Well, kids don't think so, and they're coming. They're coming. They got their boxing gloves on, and they're going to come in for a fight. And that's exactly what happens 9 times out of 10. And this is exactly why this is so important. Can I say a word? And jokingly, I like to have fun with people. I said, "You hate your kids?" Nobody ever says I hate their kids. Is either you love them? I said, "Of course I love them." Then you want to get a trust and a will because if you don't do it, you may not be here, but those kids will fight. I know you're saying, "Oh, not my kids."
Yeah.
But your kids will fight for the rest of their lives if you do not have this product.
Thank you. Thank you, brother. So community property laws, as I was saying earlier, California is a community property state. So if you bought a house together like you're talking about and you're married, if you're married and you buy a house together, even though his name's on the title, it's still community property, right? What his is yours, what yours is his. No matter what you own, you can own like I said, my prize cow earlier. My wife owns half my prize cow, unfortunately. So there's only 9 states that have community property laws. Okay, California is one of them. Understand that.
Garrel,
Yes.
we have one question online. Then we have a couple hands up.
Okay.
One is, what if the husband and wife own real estate under an LLC?
Ah, great, because I own an S corp, like an LLC, and it's important for me to list into my trust agreement to say, okay, here's who's going to get the shares of stock of my LLC. So an LLC is a company, right? But if happens to you and part of that LLC, who gets those shares of an S corp or LLC or a C corp? It doesn't matter what you own. Who gets those shares? Well, your spouse is first in line. Why? Community property, right? But after she's gone, you and her, something happens to both of you, who gets those shares of that company? It better be in your trust. You better open up a trust account or get a trust done and dictate that. It has to be written on a piece of paper somewhere, whether it's maybe a will. Put on a will. Who gets the shares of your LLC? So it's now becomes shares, not ownership.
So if you receive an inheritance when you're married, that is not community property in California. Is that correct?
That is correct. Yep. And I often encourage. he goes, yeah, I'm a financial advisor. I don't hold anything back. If I sit down with somebody and I know that they have they came into a marriage after maybe a prior one and they own property, whatever, or someone passes away, and I always encourage them. I said, keep it separate and list them as the beneficiary. If something happens to me, it's yours. But if the marriage doesn't last, it's still yours. And that's something that maybe you built up with your ex-husband or whatever for 20, 30 years, or there's several different scenarios. And for your kids, if you want your kids to get it, you come into the Brady Bunch scenario where two families are joining together, but yet it's important for the husband to leave some assets to his kids and for her to leave assets to his kids. So if you commingle it, then one person passes away, she can do anything she wants with it, right? She can give it all to her kids and leave his kids out of it. So this is a part of estate planning. These are important questions, right? Contracts like life insurance and annuities and pension and retirement accounts, that's distribution strategies because you can always list the beneficiary. It doesn't have to be in the name of a trust. If you have a 401k, an IRA, a pension, annuities or life insurance, they already have beneficiaries on it, or they should. And so that's okay. Just keep checking on it.
sorry to keep asking, but earlier you said that the 401ks and all the retirement accounts, that those had beneficiaries. So they that's where that would go. But you also, and IRAs too, I believe. But you said the brokerage account, even though you have beneficiary in a brokerage account, you still, does that qualify as?
I probably meant IRA at a brokerage account. But yeah,
Brokerage account also has a beneficiary.
they typically don't. Yeah, so you can
Add one.
add TODs, transfer on death accounts. That's the only way to do it. So you can have a joint joint account with your wife or an individual account. If it's an individual account or even a joint account, a brokerage account, there's no beneficiaries on it unless you add them.
Oh
That's-
yeah, oh yeah.
Unless you add a transfer on death account. And typically it's a separate paperwork. Like when we set up a joint account, it's a joint account. But if I want to set up a joint TOD transfer on death account, it's a whole different paperwork. Matter of fact, we can't even add TODs, right, Justin, onto joint accounts. They have to fill out all new TOD accounts. Paperwork.
Keep asking question. So the step up in basis doesn't apply to a traditional investment account?
Oh, it would. Yeah,
Okay.
absolutely would.
And so, okay. And so you can do a beneficiary for that account.
Yeah, it doesn't matter in an IRA. It's all taxable when it comes out. But in a regular brokerage account, you buy
Yeah.
a stock at 10, it goes to 20, and something happens to you, it gets a step up in basis.
And so the beneficiary would then do the same thing as far as owning a house.
Yeah.
And there would be no tax impact. if they sold.
Correct.
Okay.
Yeah, if they inherit it at 20 and sell it at 20, then there's no tax consequence. Yep. Good
Garrett,
question.
one more question online. If I own a home and the husband signed a waiver of interest, I can leave it to my son, and my husband cannot get it if it went to probate.
Correct. I mean, if he signed, that's the whole thing. Like when if we open up an account at as financial advisors, and we do not list the spouse as the 100% beneficiary, they have to sign off on it. But they can, meaning we're married, and I opened up an account, and I want my children to be the beneficiary of that account, an IRA. You have to sign off on that to allow me to do that in a community property state. I like, huh? All right. The importance of beneficiary designations. Now, again, when we talked about this, primary and secondary beneficiaries, per stirpes versus per capita. I'll just be real fast on this one because it's important. So when you're setting up your beneficiaries, how did I skip forward that much? Oh, I'm going forward. How do I go backwards? Other side? Duh. There we go. All right, per stirpes versus per capita. Does anyone know what that is? So when you're doing your beneficiaries, if you do per stirpes, it and let's say, let me give an example. So we're married again. Hi, honey. These are our two kids. Okay. If something happens to both of us and the account is set up for beneficiaries per stirpes, you're a beneficiary, 50%, and you're a 50% beneficiary, son, daughter. But you each have kids. So if something happens to you, you predecease me, then he would normally get 100% of the money, right? But I set it up as per stirpes so that if something does happen to you, your children get it. He gets his 50%. The other 50% goes to your children or your downline. Okay, that's per stirpes. Per capita is you're my beneficiaries. Something happens to both of us. You get 50%, you get 50%. But if you predecease me, he gets 100%. That's per capita. So when you're setting up your IRAs or anything else like that, make sure you ask them. A lot of people, it's always per capita. They're lazy. Not all of them. There's some fantastic financial advisors. Some of them are really good friends of mine. But I've seen so many lazy documents. You know why? It's just paperwork. they're skipping, they're going through the paperwork so fast, they don't set up the beneficiaries correctly. Per stirpies versus per capita. Do you want your downline to get it? Which is important for me because I went to my mom. I said, Mom, if something happens to me, do my kids get your money? Right? I mean, or does it go to my other sister, my sister and my brother? Right? So she did. She didn't know it, but she did want my children to get part of my money if something happens to me. So we changed it. It's important. I'm greedy, man. I got to get it. Trust strategies. All right, how much time? I only have a couple minutes, right? We got people home for the Dodgers. Okay. What is a trust? A trust is a legal document under which one person or institution controls property given by another person for the benefit of a third party. All that means is, okay, I'm going to get a trust done, and in that trust, the whole reason I'm getting this trust done is for who? A third party beneficiaries, right? So they don't have to go through probate. They don't have to do, again, you can go to an attorney and say, okay, here's who I want to get my assets. My house is worth $800,000. I want that sold and split between 3 of my kids, period. No ifs, ands, and buts about it. My trust dictates that. Some trusts might say, okay, I have a house. I want to leave it to my kids. So they inherit a house, and 3 of them have to decide, or an executor has to decide who's going to own the house, right? Be specific. So that's what a trust is. It's a legal document dictating where your assets go if something happens to you. So again, I'm the grantor. That's my house or my brokerage account. I put it all under trust, name. That's it. I have a trustee attached to it if something should happen to me to distribute my assets to a third party beneficiary. Okay, let's go back. A trust is just a legal document. Does anyone have a joint account at the bank? A joint account. It's all individual accounts? Joint? Okay. Or how about an individual account at the bank? Do you have a bank account, a savings account? Okay. If you have doesn't matter. The question is, how is that, if it's under individual or joint name, who gets that money if something happens to you? That's a non-qualified asset, meaning it's like a house. Who gets your house? Who gets your savings account? Who gets your brokerage account? Not an IRA, your brokerage account, meaning non-qualified. Ask yourself that, and then you say, well, I don't know. Well, then you need a trust to dictate that, or draw it up on a will. Remember, wills go to probate. A trust is a legal document just basically dictating, here's what I want done. Be specific. My house is going to be sold. It's going to be split between 3 of my girls, my daughters. Okay? If something happens to my oldest daughter, predeceases me, her third would go to my grandchildren. Okay? It's just part of document. Just think of words, and they call it a trust. So you drop this nice little trust. Then you have to fund it. Meaning, what's that mean? Well, you need to change your brokerage account. Yes. You have to change your brokerage account instead of the name of Mrs. McGillicuddy, Mrs. Ruth McGillicuddy. No one's named McGillicuddy here, is there? Ruth McGillicuddy individually owned brokerage account. Now it's going to say the McGillicuddy Family Trust. That's all it is. You change the name of the account. Still the same social security number, same birth date. It's just now it's titled under trust name. You do have to go. So now you need to move the house under trust name. Okay? And a good attorney will do that for you. So I'll just let you know, my trust name is Perdicio Acetes of Family Trust. You know what that means? Absolutely nothing. It has, those 2 words don't exist. But I thought it sounded like Paradise Assets. So I said, okay, that's what my trust name is going to be. And it has a date. Every trust, the day you sign that document, has a birth date. So I signed it on January 1st of 2008, whatever. That's the birth date of the trust, but it's still under my social security number, right? So all you're doing is you're changing your accounts to the name of the trust. So when I get my tax bill from the tax assessor, who I just had lunch with this week, and so did Justin, I kept telling him to stop sending me those bills. But on my tax assessment, it says Paradiso Cestus of Family Trust.
Garrow, that goes back to what you talked about at the beginning about Michael Jackson.
Yes. Yeah, exactly. Thank you. So Michael Jackson had a nice document. He didn't fund it. He didn't put a house under the trust name. He didn't put an account under. He had a nice, cool little $1 million trust, whatever it cost him to make that thing, because it was extensive. But he failed to put some things under trust name. Yeah, it wasn't his fault. It should have been the attorney, right? The attorney should have here. Give me your assets. I know there are attorneys out there, whether it's with Young Woldridge or Klein Dinatelli or Kyle Jones from Law Office of Kyle Jones. I know the fact that they, when they ask for details, they want to know your assets. And you know why? Because they want to tell you what to do. They want to say, okay, this needs to move under trust. This needs to move under trust. This need, right, Frank? It's important for them to know that. All right, good. Get a trust done. Move assets under trust name. Yes. Great question. The question is, how often should your trust be reviewed? I would say if there's any dramatic change in your family at any time, someone passes away, a wife, a child, or whatever, grandbaby, a new asset that you bought, it should be reviewed. And if it that way, they can either add something to your trust or move an asset under trust name, or an attorney can, and or add a beneficiary to your trust. So anytime there's something happening in your family, like I have now, since I've reviewed my last trust, I've had a new grandbaby. I have 3 girls, by the way. I have 3 daughters. My dogs are girls. My 3 daughters, my dogs are girls, and my grandkids are girls. I finally got a boy, grandbaby. Yeah. So I'm reviewing my trust because of that. That's what it came down to.
Also, if something was to happen to my wife and I, my son is the trustee. What does he do with the document?
Great question. So his son is the trustee of his estate, like the executive trustee, right? He steps in to be the trust. You're trustees now, but if something happens to both of them, their son steps in to handle the estate as a trustee. So the question is, well, what does he need to do? He needs a death certificate and a trust document. He needs the trust, death certificate, and you can go basically into the bank and say, hey, I'm the trustee. Here it is. It says it right here on my trust. I'm the trustee. Here's a death certificate. I'd like to make some changes and settle this estate accordingly. It's not hard.
Yep.
Plus, a good financial advisor will walk them through it and make it very easy, because you're already devastated. When someone comes to my office and they just lost a loved one, last thing they want to start thinking about is how to settle an estate, right? As a good financial advisor, I say, hey, here's what we need. I'll write it down for you. Boom, boom, boom. Take your time. When you're ready for these things, bring them back in and we can help you settle this. Yes. Therese.
If you in your trust, if you want to make sure that the trustee is paid for expenses that come out of their pockets while they're taking care of all your trust, dealing with all the paperwork, time, how do you designate that in your trust?
That's a great question, because a trustee is typically, because it's a lot of work. I mean, and you're probably grieving. You're trying to handle your brothers and sisters if you're in a family like that. And in my trust, I dictated. I said, you know what? Allow this child of mine, my oldest daughter, when you settle this trust, I want you to get an extra 3%. Okay, and I dictated it. But typically, a trustee can add whatever figure they want. they can say, oh, I want 1%, 2%, 3%. If it's $1 million estate, take 30,000. I'm settling this estate, right? Nancy, that's typically what people do, right? About 1 to 3%. Nancy Smith, about right? Yeah. Huh? Oh, hourly fees, yeah. Yeah. If you do that, you better document it all, because again, if I was the brother and he was charging me hourly fees, I'm like, dude, really?
Hey, Garrett, quick question online. This person wants to know, do all assets, cars, recreational vehicles, etc., need to be placed in a living trust?
Great question. So the answer is no. If you don't have over $185,000 in assets, there's what they call a pour over will or an easy trust agreement that they can fill out in the end to be able to move those assets to beneficiaries quicker. Huh? I think it's 182,000, 185,000 for a quick deed, a quick trust? Yeah. Yeah. I think it's 180,000 right now, to where but still, I would still place it under trust name. For instance, like vehicles, if they fail to put them under trust name, there's what they call a pour over will that handles a lot of that stuff, especially vehicles. My car isn't owned by my trust. It's owned under, I think my wife owns it. I better find out. Hold on. Let me jot that down. Let it go back to the bank. I'm not a car guy. I don't buy new cars. I'm just not I'm from Wyoming. I have a horse. Yeah. Yeah, you. Sorry. Another great question. So the question is, what do you think of co-trustees? So I did a lot of thinking with myself on that. I have 3 very beautiful, smart, loving daughters, and I love every one of them. But I just basically said, hey, I don't want 2 signatures to happen. I don't want my daughter who is in um, Tennessee to have to fly back and try to handle an estate. And so I made one of my daughters the main trustee, and I talked to the other ones. They said thank you, and I did the same thing for my mom. I said, Mom, I don't want to be the trustee of your estate. I know I'm in the business, but Gail, my younger sister, who I was going to leave my kids to, little mama, she'll handle it way better than I can. So she's the sole trustee of that account. My mom wanted to list a lot of us, all of us on there. I said, no, don't do that. To me, it's cleaner. Just make one person. Give them the extra 3% or 1%. Typically, it's 1%. But you can. Mine was 3%. Yeah. All right. I think we're almost done here. So, types of trust: testamentary trust. Which one do you want? Testamentary trust or a living trust? Which would you rather have, do you think? Why? You're still alive. Yeah. Plus, a testamentary, that's exactly right. Guess when a testamentary trust is developed? When you're dead. And guess who does it? Your will going to probate, and the judge says, okay, that's a testamentary trust. We now have one, but you didn't have one prior. That's done at death. A living trust is while you're living. Revocable versus irrevocable. I don't want to spend a whole lot of time on this. Property, revocable trust is you can revoke it, meaning you can set up a trust and kick your kids off and kick them back on and say, hey, you're being bad. I'll put you on it. I'm not going to have you on it. I see that all the time too. Irrevocable is once you set it up, you can't change it. But the good thing about that is it's not part of your taxes either. It's a whole entity. I mean, if you set up an irrevocable trust, it has its own EIN number, its own employee identification number, which is like your social security number, right? It's irrevocable. It gets it out of your state, though. There are planning techniques if you need them to come sit down with a financial advisor. Why would you need an irrevocable trust? Well, it means to get money out of your estate and not be taxed on it later through estate taxes, right? Most people don't need one. I've only set up maybe, a couple in my life. That's it. Revocable trust. Special needs trust, I've done these a lot. Special needs trust, if you're on Social Security disability and you have a special needs child, or if something's wrong with you, and you're on Social Security disability or any other thing, or Medicare, Medigap, or there's other things that if you have something, if special need, that's all it is. Then you need a special needs trust, because let's say. Well, I had a client, several. This happened several times, that they didn't want to list their child who had special needs as a beneficiary of their trust, right? Because if they inherited the money, the Social Security disability payments would stop, okay? So we set up a special needs trust. So the trust said the special needs trust is going to inherit this money. So that not her, the special needs trust has its own what? Own EIN number, has its own entity, right? It's not under her Social Security number. So a special needs trust was set up, inherited the money with a trustee attached to help manage the money to pay rent and for a special needs child. And it continues to this day. It's a very good story. There's a lot of them like that. So I like special needs trust, especially if they're on disability, Social Security income. Okay. Incentive trust is basically what it says. It sent you to do something. Like my grandfather homesteaded land in Wyoming, And when he set up his trust, he had 42 grandchildren, whatever it was. He was comes from a family of 9. My mom's like the youngest. And so by the time I inherited my money, was like when I was 28 years old, and it hardly was anything. But because of that, I was a trust baby. Yeah, I maybe got $10,000, but incentive, because it was an incentive trust. You have to graduate college, right? That was one of the incentives. Yeah, yeah. So we all went to college, I guess. Yeah. But you can do anything. Say, hey, I want you to graduate high school. I want you to get a job. I want you to be 28 years old. I want you, there's just a few incentives to get people out there. And there it is, reviewed periodically. Tax laws changes. The composition of your holdings and the value of your assets may change. Your family situation could change, kind of like what we talked about, sir, that if there's tax law changes, more likely if there's tax law changes, we'll contact you if you have a trust with us. If everything else is the composition of your holdings change, like we talked about, family changes, that's when you want to revisit. So putting your knowledge to work, well, do it yourself, work with us, procrastinate. I wouldn't procrastinate if you have assets that need to be put under. I've seen time and time again that the people do procrastinate. They're back in our office trying to figure out what to do. So, well, you need to go to probate. You need to get a death certificate. It's going to be painful. It's going to probably be settled in a year from now. Trust, no probate, clean. It's going to cost you, but it's worth it. Wealth plus tax plus estate equals money wise. I didn't put that up there, but I like it. Good job, Debbie. You got sheets in front of you. Thank you very much. Hopefully I educated you along the way. Yes, questions. I apologize. No.
The pour over will, you said cars of the $185,000. Is that something like a codicil, like
Yes.
all your individual stuff that you got in your
Yeah.
house?
So like if you have a living trust and you have a car that's not under a trust name,
But your jewelry,
jewelry, yeah, well, that's part of a will. You too. So when the reading of the will, like you don't put your jewelry on your trust name, but it's a
Right.
good question, right? So your will dictates it though. Say, hey, I want my youngest daughter to get all my jewelry that's in safe deposit box in bank number 2 or whatever, or at home.
right? No, that's
Yeah.
what I'm
Yeah.
talking about.
But if you dictate it, then it'll be better off. If you don't dictate it, there could be a fight.
Right.
Yeah.
That's what.
Yeah.
I'm talking about.
Yeah. 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 But there's a lot of things to think about in there. Jewelry, cows, like I said.
Got a question over here, Gerald.
Yes.
What would one expect to pay for a will? I mean, a trust, a living trust.
Great question. So I always say they range a good a trust ranges anywhere from I've seen them from $1,200 all the way to $10,000. Which, by the way, when I saw $10,000, that attorney got a call from me. I said, "What are you giving away? Gold trim binders? This is ridiculous." It was in Wyoming, by the way, which they figure they can get it up in northern Wyoming. So then we asked around. I got him that trust done for $1,800, and it included a trust, a will, a healthcare directive, a power of attorney, and you get it done for much less than that here.
And it also depends on how complex your estate is going
Yeah.
to be, right? It has to do with hours the attorney is going to be putting into it. If it's going to take, a week for that attorney to do it because it's really complex,
That's
you're
exactly.
talking 10 grand.
Yeah, it depends on how complex it is. If you're Frank back there who owns 10 properties, so you need a big trust that needs to be, you need to put everything under trust name, right, Frank?
Hold on.
Had to redo a lot of those so-called online trust services. I don't want to mention any names because I could venture to say that if there's a snafu somewhere along the line, those attorneys that you contacted online are not coming to Bakersfield for you, and we are here for you.
It's a good point.
Just be mindful of that.
Yeah. So what he's talking about, online services to get your trust and will and everything done for it's less expensive than going to an attorney. That's what he's talking about. But they've had to fix a lot of those. Unfortunately, I've seen them. Yeah.
One last question for me. So when I choose you to do that service for me, do you have a list of things, itemized list I should bring with me? Prepare before I see you?
Yes. So I don't do the trust myself, but I, as a financial advisor, I direct you to get your trust done. And so if you want to come in as a financial client, then I would do a whole discovery with you. We all would. I mean, hey, I want to discover who you are. Why am I investing your money? And I'll propose something to you. Realizing you don't have a trust done, then I'll write an attorney's name down that I think would be a good fit for you. And then I usually, personally, I walk you in. I mean, it's my thing. Not everybody does it. I know your data. I now know you, so I know what needs to go under trust. I need to know. So I have actually walked most of my clients into an attorney's office and said, "Here's what they need," because it's confusing enough. But, yeah.
Garrett, one last question from online. Can you have both a revocable and an irrevocable trust concurrently?
Yes, you can. Yeah. Yeah. One's irrevocable, one's revocable. Yeah. And that typically happens when you have a large estate, if you have one, and you need to move some of it out of the estate into irrevocable because it's its own entity. It gets out of your estate. And then, but you still have a living trust for everything else you have outside your irrevocable trust.
Are you a fiduciary?
I am a fiduciary. I am a financial advisor. It's a good question. Thank you. It takes a certain license to get that, and you can't work at MoneyWise and as a financial advisor until you get that, and that's where we figured the Department of Labor is trying to get everyone to, and it's called a financial advisor. It's just basically a law license through securities law, and able to call ourselves fiduciaries. And what that means is, I said it earlier, as a fiduciary held to that responsibility, we have to do what's right for the client. That's a fiduciary. And so when the SEC ever sits down in front of us and says, "Hey, tell us about Mrs. McGillicuddy," we better know everything about Mrs. McGillicuddy because we're investing in their money. A lot of licenses, whether it's a stockbroker or anything else, sometimes you just have to fill out a questionnaire. They can invest your money, and sometimes there's no repercussions. We're held to that responsibility. Thank you for that.
I'm thinking about getting like a CD right now. So you said a CD, if I don't want it to go to my husband, he has to sign off of it if I want to just put it in my kid's name or one of my grandkids' names.
Yeah, so if you put it in one of your kids' names, it's a gift. You can do that. Meaning you go into the bank and say, "Hey, I wanted this under my child, granddaughter, or whatever." You can put it under their name and write a check to it, and it's theirs. It's no longer yours. You have no control over it. But if you're doing it as a custodian for the benefit of a child, then that's a different story. So it still would go, you're still buying it for a child as a custodianship. Because remember, you have to be a certain age to invest money. So if it's for a child, you'd have to put it in your name and or banks. If it's like savings account, or you're thinking CDs, you said, right? Okay. Mike, can you answer that then? I guess
Yeah,
if it's a CD,
she
just put it in
essentially
their name.
wants to know, you want to open a CD and you want the beneficiary of that CD, should something happen to you, to be a grandchild.
Oh, the
Maybe they
beneficiary.
have to be of
Got it.
any particular age? No. Not in
No.
our case.
No.
No.
No, not that bank make money. Now, if something were to happen to you and he knew that was there, yeah, community property rules would step in and say, "Hey, yeah, I would." What do you mean you gave her 10 grand? She didn't even take out the garbage. All right. I think that's the last slide.
Yeah.
So here's who we are moving forward. One of the things we like to do, just so you know, we are an advisor. We like to strategically talk about, how to get rid of your emotions when you're investing, and we talk about estate planning and changing tax laws. We stay on top of all that, but we always like to talk about goals. But here's typically, great. Yeah, we're done.
Yeah.
Yeah, I'm done. There. This is our wheel, and I think every business can. If you're a business owner, look at it. This is a structure of a good company that knows how to produce a strategic format. So we mutually discover you. we evaluate you and whatever you told us, kind of like we were talking about. I better know you. We've come up with solutions and presentations. Even though we have that, the problem is there's a lot of solutions out there. We have to implement it. We go to our quarterly fiduciary reviews every year, and then that's the wheel. It starts all over again. Banks are like that. Safe1's like that. We have a great relationship with Safe1 now, and and we actually love it. And so the structure of business with them is similar to ours, to make sure you're all taken care of. And thanks for having me. I'm glad to
Right.
have Safe1 out. I'm glad Safe1 had me up here to talk about that.
I would like to second that. Thank you, Michael George, and Safe1 Credit Union for having MoneyWise as a guest speaker. We really appreciate you guys, and we are proud to be community partners. We have David King, who's the president of Safe1 back there, and Mary Higgins, who's the compliance and operations officer. Great team. If you need a home loan, car loan, any banking needs, some of you are Safe1 customers already. I know there's a couple of MoneyWise clients in here. Thank you. If you need any help, please contact Safe1.
And thank you, Garrow.
You're welcome. Thank you very much. Get home,
Garrow,
watch the
end it-
Dodgers.
End it how you do the radio show. Be safe, be smart.
Be safe, be smart, be MoneyWise.
Yeah.